Good afternoon. Welcome to the Appellate Division, First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People v. Jeffrey Tart. Submitted. Quezada v. City of New York. 4 and 1 and 5. Thank you. G. Kayana, which actually should be Tayana, is submitted. Garcia v. 100 Church Street fee owner. How much time do you want?
Submission.
Oh, submitting. Both sides? Very well. Thank you. People v. Sindhu Sise is actually 2 appeals.
For the defendant appellate, be awarded 5 minutes.
For, is this People v. Sise?
Yeah.
Okay, I'm sorry if I mispronounced his name. You need how much time? 5. Do you want any time in rebuttal? 2 minutes. You got the Bronx and Manhattan, so where are you from?
Sure. Manhattan, Your Honor. Just 2 minutes. 5 Bronx, 3 minutes.
Very well. 5 and 2 and 2 and 3. URP Maiden Lane v. Valley National. Yes? Okay. I'll give you 6 and 2 and 7. Thank you. Bordenaro v. E.C. Provini. Which defendant appellant? Very well. How much time do you want? 4 and 1. Very well. Plaintiff?
Plaintiff responded, 3 minutes.
I'm going to give you guys a little more time because I think we have more questions for you. So 5 and 2 and 5 and 2 and 6. Thank you. We may not use it. We'll see. C. Narcida v. Crystal C. Submitted. RSD 857 LLC v. Wright. Give you 4 and 2 and 4. People v. Abdullahi Shuai. Sorry if I'm mispronouncing that. People v. Shuai. Submitted. Zepsa Industries v. 401 West Property. How much? 3. 3, all right. 6 and 2 and 3. Sheziak v. Airy Tenant. 5 and 2 and 5. Biswas v. Aramis Distributors. 5 and 2 and 5. Lee, be Montefiore Medical Center.
Good afternoon, Your Honor. Respondent Montefiore requests for one, please.
Helen.
I'm the appellate, one person.
4 and 1 and 4.
Thank you.
People v. Leak. Submitted. Blenbaum v. Chan is submitted. Okay, we'll begin with Quezada v. City of New York.
May it please the court, my name is Dan Ratner. I represent Con Edison on this appeal. There is no evidence in the record, this is a summary judgment appeal. There's no evidence in the record that Con Edison was ever notified about any condition on the FDR drive around exit 7.
You concede that there was a manhole cover that had the words Con Edison on it, roughly 100 feet from the exit or so, or more than 100 feet?
Well, at the time of the accident, the testimony in the record is that the plaintiff looked down, saw a lid next to, on the side of the road after he was struck.
Right after he struck, he was
overheard-
not able to say it was Con Edison. He heard some hearsay that it was Con Edison.
2 weeks later, far left lane, he went back and took photographs and found the Con Edison manhole, among other manhole covers in that area, which were closer to where the vehicle was struck. But even assuming the circumstantial evidence, even assuming that there was a Con Edison manhole cover nearby, and even assuming...
What about the DOT tickets? Do they provide notice of any kind?
Well, thank you for asking that question, and that's the thing. No, there's none. Every one of them talks about various conditions not around the time of the accident or involving different types of conditions like replacing, gas mains or things like that. There's not a single notification to Con Edison about a loose manhole cover. There was one on the day of the accident that was reported to the Department.
Right, that was a 311 call.
I'm sorry, I didn't catch your question. I'm really sorry.
Oh, what was heard on the day of the accident was a 311 call, right?
Yes, and the problem there is that a 311 call has to make its way to Con Edison. It didn't.
No, that's fair.
I mean, that's the point I'm trying to make.
Let's
There's no
talk about the
notice.
tickets. So there's one that concerns an overhead lighting. That's at record 304.
Yep.
Was that provide any notice?
Overhead lighting of
It doesn't sound like a
overhead
manhole
lighting.
to me, but I'm just wondering, does it?
No.
you know?
No, Your Honor, it doesn't. I mean, what we want to see is something saying there's a problem with a manhole cover to Con Edison, and there wasn't.
Can I point you to page 306 in the record? It's the same ticket. It says for the purpose of repair, electric communication. Wouldn't that put you on notice that how would you go about repairing electrical and the communications if you don't go below the ground?
Well, I think the issue here was whether there was a loose manhole cover, and those things do get reported, on a daily basis to Con Edison. There's millions of them.
Isn't it convenient a week before the accident that you were doing work in that very manhole and it then is loosened and it then hits the plaintiff? Why isn't that circumstantial evidence?
Because there's no report to Con Edison that they created a dangerous condition that needs
If it wasn't
to be
create,
remedied.
you don't need notice. You have created the condition.
Well, I don't see where the evidence is that the manhole cover was left in some sort of a dangerous state. I mean, that's the argument that we're making.
Correct.
I mean, I understand this is summary judgment, but my take on it is that summary judgment, the idea of going to a trial is not to resolve a mystery. It's to establish, first you have to establish that there are actual material, triable issues of fact. And here what you have is a manhole cover located on the far left lane of the FDR. Somehow it flew across 2 lanes of traffic. And Con Edison, even assuming that was something that could actually happen, that's known to man that could happen, even assuming that, Con Edison knew nothing about it, and there's no evidence that they created this condition.
But the permit from 7 days before the accident that allowed you to occupy the roadway where the accident occurred for the purpose of the street line arm removal, which may have had some involvement with this area, together with the circumstantial evidence that a plaintiff overheard the EMS people talking about the Con Ed cover. Obviously, he was not in a position to look at it after he and his car got struck by it as he was driving on the FDR. Doesn't that at least give us enough to prevent you from getting summary judgment?
Judge Kapnick, I see my time's up. I'd like to just quickly
please.
answer. A permit in the case law does not equal actual work being done. And it's cited in our brief. Just because a permit is issued doesn't mean there was actual work done. There would need to be other documentation of the work actually being done. And there was no documentation of that work being done. So that's my answer to that question.
Thank you, counsel. You have time in rebuttal as well.
Thank you, Your Honor.
May it please the court. Good afternoon. My name is Stacy Van Malden, and I represent Mr. Quezada.
Hey, counsel, before you start,
Yes,
why did you cite, well, I'm just telling you, don't cite to NISIS documents if it's in the record on appeal. That's not helpful to us in any way.
my apologies. There were many documents that were not included.
The crucial documents were, if you can cite to the record on appeal, then do so, and tell us why we should consider something that's in NISIS if we have to. Please continue with your argument.
Yes, Your Honor. Round things roll. So for Con Edison to say that their manhole cover could not be where the accident occurred, certainly circumstantially, it could be. The cases that Con Ed cites regarding notice, those cases are city cases where you need actual or written notice. There's a different standard when you're dealing with sovereign immunity. In this case, I would submit to the court that there is sufficient circumstantial evidence to show that it was a Con Ed.
Would you concede, though, that the existence of a ticket does not mean that the work was actually done?
I absolutely would concede the work may not have been done, but how do you get the permit? The way to get the permit is how do you know you need a permit? You have to go, you have to inspect, you have to see. So that they didn't do the work just shows more negligence rather than saying, I mean, they applied for a permit the year before in the same place, and then they applied for a permit a few days before.
Do you have any case that provides a negative inference when work is not done pursuant to a permit?
No, I don't. And I don't know that there is.
Counsel, can you point to anything in the record where Con Ed stated they did no work pursuant to this permit on August 10, 2015?
Point to something in the record where they
Is there anything establishing that they didn't do work? Was there testimony? Was there documentation? What? Because you heard your worthy adversary state that a permit doesn't mean that work was done. Is there any affirmative evidence that no work was done on that particular day on August 10, 2015?
Yes, I can't point to you exactly, but I know that in the record there was deposition testimony by employees of Con Edison saying that these permits were issued, but that no work had been done. So the other point I wanted to make was regarding the identity and the ownership of Con Edison. Now, I know that Mr. Quezada, of course, at the time of the accident could not identify it, and that it's hearsay that he heard the fire department. And the words that they said are certainly hearsay. But what he did see on that day was fire department personnel around the manhole cover that he went back to photograph. And that is sufficient to at least raise a question, a genuine issue, a fact, as to whose manhole cover that was, and with legitimate admissible evidence, because he did see that. And then he went back and he found that it was indeed a Con Ed manhole.
Counsel, what is undisputed is that there is a Con Ed manhole on the roadway on the left lane, correct?
Correct.
So it does exist there, near where the accident occurred, correct?
It's close enough to it. It's, there have been different measurements. One is 200 feet, one is 150 feet. But as I started with, round things roll. and things get hit by cars, they fly. There's all sorts of physics involved that makes it possible. It's not speculative. That manhole cover could very well have hit Mr. Quezada's car. According to what he saw, there were fire department personnel around that hole, so there was probably something wrong there. It's certainly a logical inference that can be
Counsel,
made.
is there another manhole cover near that area, near the exit?
I did not see the exhibits in real life, only in the record, and it was difficult to make out. The appellant says that there were 2 other manholes in that area. The photographs that I was able to see only show the Con Ed one that is kind of in the middle of the left and right lane, right on the line.
As plaintiff testified, the cover was he was in the middle lane, and the cover was near the middle to the left lane, the one that caused the accident?
He was, I think he was going from the middle to the right lane. So I would ask that the lower court decision be affirmed. Thank you.
Thank you, counsel.
I'd like to just quickly address Judge Hagler's question about the lack of evidence in the record that work was performed or wasn't performed. I'm trying not to say double negatives, but that's the problem, right? In these cases, we're in the position of having to prove a negative. So how do we do that? We do a record search. We look back 2 years, we look for opening tickets, emergency control tickets, permits, and see what they add up to. No one is arguing that the search in this case was inadequate. The search was the search, and it didn't uncover any work being done. So I'm hoping that answers your question, Your Honor.
Thank you.
Regarding the issue of other manhole covers that Judge Mendez asked about, there was testimony in the record that there were manhole covers depicted in the right and center lanes, and Mr. Blasey of Con Edison said they were not Con Edison manhole covers. That's at pages 395, 397, 401, 403, and 405 of the record. I don't think there's any dispute that there were other manhole covers closer to where, at the right lane, basically, where the vehicle was struck. Thank you, Your Honor.
Thank you, counsel. Thank you both.
Thank you.
People v. Cisse. Counsel, it is pronounced Cisse, is it not?
Yes.
Thank you. Please give your appearance. Thank you.
Yes, may it please the court, my name is Peter Gordon. I represent the defendant appellate, Sindao Cisse. At 1:26 a.m. on New Year's Day, 2023, Mr. Cisse was lawfully along Webster Avenue. A team of plainclothes officers in an unmarked car made a U-turn, shouted stop, and pursued him before any crime had been seen.
Were they pursuing him, though? That's an important question. You say yes, but what were the indicia of pursuit there? What indicia of pursuit was there by the officers once they made the U-turn? Is the U-turn enough to show pursuit?
The U-turn was the impetus of him abandoning the property.
Not my question.
Okay?
Were the police pursuing him?
No, they just were on a regular patrol. They were running 2 teams of 3 men marked, unmarked cars. And the 2 teams were not coordinated by anything. It was just coincidental that they showed up. The one team that showed up on the far corner, and Detective Alvarez, who said he saw the placement of a weapon, which was almost 180 to 200 feet away. I had a surveyor ready to testify at the hearing where the judge prevented me from having the surveyor come in to testify regarding how far that distance was. So the gun was not abandoned until the police officer and Officer Bertulli, as he testified, that he saw in his eyes something guilt, and then they made the U-turn.
Counsel,
I'm sorry.
respectfully,
Yes.
not one of the teams stopped your client before he abandoned the gun. There was he was never stopped. There was no communication. There was no level one questioning. What's your name, address, why are you doing here? Information that would otherwise be appropriate for the level one under the DeBoer standard. It was only when your client was hiding behind a car and was seen by the second car to have placed what was in his waistband into the well of the wheel of the car he was hiding behind.
He was already in pursuit at that point. That was the U-turn that was made.
There was no pursuit.
There was a U-turn made to him, and as a result of that U-turn, that's what led him to move. That's what's in the evidence. It's uncontroverted. It's in the evidence.
So when the police make the U-turn, when the police vehicle makes the U-turn, they have not yet engaged your client, correct?
Well, they actually, in this particular case, they have because of the eyes from Officer Batou.
Did they call out his name?
Not at that
Did
point.
they tell him to stop?
Not at the U-turn.
Did they call him over and said, come over to our vehicle
Not
at that
the
point?
U-turn.
No. So they're making the U-turn, and your client sees them make the U-turn.
Yes.
And then once he sees them make the U-turn, then he proceeds to place his hand in his waistband, take out whatever he had, and place it on top of the tire.
If I may, before he did that, that's when he went behind the van.
So when he
From
goes,
the pursuit, not the pursuit, from the U-turn, which I think is pursuit, but from the U-turn, that's when he moved behind the van.
and at that point, even when he moves behind the van, no one has called for him, no one has told him to stop doing what he's doing, no one has said anything to him.
Not at that point.
Not at that point. So they engage him after he emerges from behind the van. Is that what happens?
After he emerges,
Right.
Then they detain him, and he tries to run away, and they yell, stop.
Okay. But before that occurs, as testified to by Officer Alvarez at the hearing, he says he saw your client place something on the tire of the van.
Yes.
And he radioed that he saw something, he saw him place something on the tire of the van.
No, that's not what happened. He did not radio. There was no transfer of the intent or what Detective Alvarez saw in his mind to the detectives who detained Sisse. There was nothing there. It was just coincidence that they were there.
So there was no communication, no radio communication
That was
between.
I asked that at the hearing. There was nothing there. It was just luck. And they even said it. It's excited utterance. They scream out, "What are the chances?"
I thought that was just that they had worked together before and they weren't, unexpectedly, they met up that night.
As
at Bronx.
explained by the detective, but, that's okay. The factual situation is the abandonment happened as a result of the U-turn and what is pursuit. It was a flight that was provoked by the state.
But if we look at the bore, is the fact that a police vehicle makes a U-turn, is that considered a level of intrusion?
No.
It's not.
But the abandonment of the property was caused by that, and the DeBoer level 1 didn't trigger till after they said stop the police officers. They could have said stop, and he chose not to, and he fled. They didn't have a reasonable suspicion at that point. He was
But the officer actually engaged the defendant by saying
They
stop.
retained them. They retained them.
Exactly.
They
Which didn't happen here because all they did was make a U-turn.
He abandoned the property as a result of the U-turn and the sighting by the unmarked police officer who testified. He looked him in the eye, and he saw something suspicious. As a result of that, defendant goes behind the van, tries to walk out of the path behind the van, and he abandons his property at that point.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honor. Joseph Tucker for the People, Bronx County. I thought that I would go first since it
Makes sense.
relates to this. Thank you, Your I think what counsel is arguing is that any time a guilty individual is carrying a weapon or drugs or stolen property, if they see the cops, they abandon it, and it's the police fault. And that's not the standard. The standard has to be that the police take some action that causes someone who would...
It has to be unlawful police action that causes them to get rid of whatever they're carrying, and then it may be suppressed in that circumstance, correct?
Correct. And in this circumstance, that never happened. I mean, it's very clear from the facts and what happened at the hearing court, what came out elicited at the hearing court was that the police made the U-turn, didn't even approach him, didn't put their sirens on, didn't put their turret lights on or anything. Yes.
Counsel, I just want to understand, your friend keeps focusing on the pursuit triggered the abandonment. I didn't get anything from the fact that there was a pursuit. My understanding that the first car went by the defendant, routine patrol, the defendant saw the car and acted in a suspicious way, holding the side of his waistband, starting to walk a little quicker. Again, they were surveying him. As far as I understand under the law, surveying a citizen of New York is in pursuit, correct?
Absolutely correct. And that's exactly what the police are supposed to
So
do.
when he characterized the U-turn as pursuit, that's not accurate.
It's inaccurate. The police were just patrolling, usual patrol. They saw somebody that looked suspicious to them. They made a turn. They didn't even reach a level 1 Deborah, in the actions that they took. They just stopped in front of the van. He never appeared. And one officer out of the 4 stepped out of the vehicle to see where he was. Before that even happened, the defendant made an independent, calculated determination to abandon the property. And that's what the hearing court found. I believe the hearing court was correct. If there's no further questions, I'll rely on my brief, Your Honor.
Thank you, counsel.
Thank you.
We're going to hear from Manhattan next.
Good afternoon, Your Honors. Hunter Barron for the people. I'm from Manhattan. Because these sentences were run concurrently, our appeal really rises and falls on whether the defendant's Bronx conviction is vacated or affirmed. So unless Your Honors have any questions on our... Okay.
Well, you also have the argument that they can't even make the argument about what happened in the Bronx in your appeal, correct?
Right, because the suppression ruling was in a separate case, and the suppression record in the Bronx isn't even part of our appeal. So unless Your Honors have... Thank
I
you.
don't think so. Thank you, counsel.
I'd like to point out that after the abandonment of the property, that's when he was detained. It wasn't, that was a level 1, and they didn't have a suspicion at that time.
So counsel, let me stop you. I thought the record was that Detective Alvarez, quote, alerted other officers and about the placement of the firearm, and only later Sergeant Riley chased after Alvarez and said that he put it on the wheel.
No, that's exactly the opposite. Detective Alvarez, when he screamed after they were chasing him, checked the van on the wheel. I don't remember the specific words he said.
Put it on the wheel was the
Right, but at that point, they were already chasing him. He went, to the next block through a gas station, and they were chasing him. So he was already being detained at that point.
Can I stop you? When did Sergeant Riley chase the defendant? Give me because I thought it was the opposite of what you just said.
So he abandons the property,
Right.
comes out behind the van.
Can you tell me first when the statement it was put on the wheel? When did that occur? Did that occur before Sergeant Riley chased after the defendant or after? Because I thought it was Detective Alvarez first stated he put it on the wheel, and then subsequently the sergeant chased after the defendant.
No, he was already being chased at that point. He was already in hot pursuit, and he was running, trying to get out of there.
What does
And
hot
within-
pursuit
within the-
mean? Because we have different definitions. Just tell me, instead of a conclusion, tell me what happened.
After they said stop, then he ran, and then the 3 from one of the marked cars with Riley, and they chased him, and then Alvarez screamed at that point. So this was after they were already running, and like His Honor said, it was coincidental that they happened to be together, and what is the luck? But there was no radio call or anything between them, look, you got to find this, or anything like that. It was just, it happened so fast. The defendant's abandonment of the property was clearly reactionary to the officer who said he looked him in the eye and saw something suspicious. They did a U-turn at that point. He then went behind the van, abandoned the property, comes out of the van, gets immediately detained at that point, tries to run away, and then Alvarez turns the corner, checked the van, I think the wheel base or something on the van was his specific words.
So you're saying that, didn't they have to run after this gentleman
Yes,
quite a distance? A lot of
Yes.
officers ran after him.
yes. I think at least 4 I see in the video running after.
Right. So when they run after him, he has already abandoned the property. When they're running after him, he has already abandoned the property.
Yes.
And when he abandons the property, no officer has yet approached him, called him, detained him, or anything. He does it on his own when he sees the officers make a U-turn.
On his own, no. When he sees them, he does it.
Okay.
It's not, there's a difference. There's something that, it's a reaction.
Nobody, when he abandons the property, nobody has called out to him. Nobody has
Well, I think.
Walked up to him.
U-turn that was
Well,
done.
you're saying that it was the U-turn.
Yes,
the
because
fact
that's like
of
the
U-turn.
Starsky and Hutch U-turn that comes right there.
Okay.
And there's no one on the street. It's 1:26 in the morning. There's no one on the street. He's the only one there.
Got it.
Thank you.
Thank you, counsel. Thank you all. URP Maiden Lane, V Valley National Bank, et al. Please.
Good afternoon, Your Honor. If it pleases the court, Brian Lineback on behalf of the appellants. Your Honor, this is an appeal of each and every part of an order which denied the appellant's motion to dismiss. There are a number of points in our briefs. I will keep my statements here today to a couple of points. Number one, preliminary injunction. And I want to make sure that from the very beginning, the preliminary injunction, although there is an issue about the actual loans and whether or not the appellants can actually sell the loans, the preliminary injunction itself does not actually say that the appellants can't sell the loans. It actually says that the appellants are restrained and stayed from taking any steps to effectuate a closing. That's what the actual language is. The only reason that we put this in our papers is because the dicta of the underlying decision infers that what was intended was to prevent.
Isn't the sale of the loans tantamount to the ownership of the property?
No, that is not.
Why
that is
not?
the case. Well, because the only thing that the appellant was actually acquiring as part of the loan purchase and sale agreement was the same thing that the secured creditor has. The secured creditor does not own the actual real property itself. The secured creditor has a loan that is secured by the property. And in a foreclosure proceeding, the secured creditor's aim is, of course, to sell property to recoup their losses under the loan.
Now, there was a foreclosure action going on relating to this property separate from this,
That is
right?
correct. There is
That's
a separate.
still going on?
That is correct. There is still a foreclosure proceeding that is going forward. The appellants have obtained summary judgment in the underlying foreclosure proceeding. But the point I was going to make, Judge Kapnick, is if in a foreclosure proceeding, although it is possible that the secured creditor might obtain ownership of the property, there are a myriad of circumstances that would militate against that. For instance, the borrower has a right to redeem, to pay the actual loan proceeds and walk away with the property at any point in time before there is an actual foreclosure sale and a gavel is dropped. The borrower could file bankruptcy which would take the property completely out of the state court proceeding and make it property of a bankruptcy estate.
There was a bankruptcy at one point.
There was a bankruptcy, but the bankruptcy was not with regards to the underlying borrower's proceeding. The bankruptcy was with regards to the actual purchaser. And this is actually a key point, Judge Kapnick, because the bankruptcy was one filed by the purchaser in an attempt to obtain additional time to close under the LPSA. So under Section 108 of the Bankruptcy Code, the purchaser was given an additional 60 days.
They bought
by
time that way. That's what, and they were pretty upfront about saying that's what we're trying to do is buy
Yes.
time.
Right, and
They
then
w-
that got dismissed.
That is absolutely correct, Justice Kapnis. They were very specific that the bankruptcy was not to reorganize at all. It was merely a tactic to avail themselves of Section 108 of the Bankruptcy Code and obtain the additional 60 days. Once that 60-day period passed, the actual ability to close under the LPSA expired of its own volition. There were no additional acts that needed to be done. The actual time simply expired because the LPSA has a time is of the essence clause which required the contract to be consummated by a
The
closing.
bankruptcy court, I know you argue this, but I don't think the bankruptcy court so held. I don't think that it made a ruling about whether or not the LPSA could be, its due date could be revived and pushed out.
Well, it did not make a ruling as to whether or not the due date could be revised or pushed out. What the ruling was that the time to close had expired as of its own terms. And that's relevant because, as I said before, the underlying agreement itself has a time is of the essence clause which prevents extension.
Though it had been extended, of course.
It had been extended a number of times. Indeed, the 60-day period was a further extension, was not specifically provided for by under the contract.
And didn't the bankruptcy court judge say, well, he did say, because I have the order, that the LPA, he called it, has expired by its terms?
That is
That
correct.
was without prejudice to the parties' rights and arguments in the pending state court action, whatever those might be. He didn't say what they were, but he did find that the time to, that the LPA had expired by its terms.
Yes, that is correct, and it is extremely relevant because the action that we are here for is an action by the plaintiff to sue under the LPSA, and what they can obtain is money. What they can't do is specific performance. They can never perform under the LPSA because the LPSA has expired. That order that is an order by the bankruptcy judge that has never been appealed. It is now a final order. It cannot be collaterally attacked by the petitioner in the trial court. With
So I'm going to give you some more time than I gave you initially. Do you want to talk about some of the other causes of action, perhaps?
Yes, indeed. I'll move along to unjust enrichment. So unjust enrichment, it is black letter law that where a contract governs the subject matter of a claim, that is not the subject of an unjust enrichment action. And that is exactly the case here. Here, the plaintiff, the respondent, is suing over the LPSA. And specifically, their unjust enrichment claim seeks as damages the $6 million which the appellants only have by dint of the LPSA itself. And since the actual terms of the contract are directly implicated in the unjust enrichment claim, it is improper to maintain an unjust enrichment claim where there is a contract that's present. And I guess to be very clear, the plaintiff respondent cites to a number of cases which identify an exception to plead in the alternative, but the cases that are cited deal with circumstances where the contract at issue, where there's an actual dispute as to whether there is a binding and enforceable contract.
Here concede that there was a contract.
Indeed, both the respondent and the appellants concede that the LPSA is a binding agreement, and therefore it governs the actual subject
So
matter.
when the preliminary injunction was first granted, did you request from that judge an undertaking be posted?
So during the oral argument, there was a discussion about the preliminary injunction and whether it would be granted. And I was the attorney that argued before the
You
trial
were?
court. I was indeed. And I made a number of comments as to why a preliminary injunction should not be granted without an undertaking, because here, what we're talking about is purchase of commercial paper. These are loans for $40 million. It is a specific property with a finite number of of potential buyers, and that finite number of potential buyers could change at any moment in time based upon a number of factors in the outside world. If the appellants were restrained from being able to sell those loans to a third party, there would be injury to that fact because they might not be able to sell those loans at some point in the future. There isn't a huge pool of people that are trying to buy distressed loans for a borrower that's already in default.
Thank you, counsel. You have time in rebuttal.
Good afternoon, Your Honors. May it please the court, Seth Fior from Feuerstein Kulik LLP on behalf of the respondent. I'd like to just start with the bankruptcy order that Mr. Leinbach was discussing because it's...
Talk a little bit closer to the microphone, please, counsel.
Apologies, Your Honor. I'd like to start with the bankruptcy order because it's important to note that the bankruptcy order did not say that the time to close had expired. It said the contract had expired by its own terms, but it also said, as Your Honors noted, that it was without prejudice to the parties' rights and arguments in this litigation. But it's important to note that the bankruptcy court also noted the time factor because we sued prior to the closing date, and the first count in the amended complaint is seeking injunctive relief. And at page 422 of the record.
You did not seek specific performance as a cause of action, did you?
We did not seek specific performance, but we did seek injunctive relief to preserve our right.
So you've had an injunction for 2 years now, right?
For about a year, Your Honor.
Okay, well, it seems to me that it was longer, but in any event, why do you think that it's appropriate that if we were to let you continue on with this preliminary injunction, that there should not be some type of undertaking?
Well, Your Honors,
usually you always have to put down some type of undertaking if you get a preliminary injunction.
And, Your Honors, if the court were to affirm the preliminary injunction but remand for an undertaking, if the court felt it was appropriate, that would be acceptable. However, we don't believe there's an undertaking necessary here because appellants haven't shown any damages, and they have the burden.
Well, they can't, the injunction prevents them from closing on these loans or moving ahead with this property. It's just been standing there for years. The construction stopped 3 years ago from what it says in the papers. And it's like a partially built building just standing there for years.
It is, Your Honor.
It's not damages?
But there's no damages from them not being able to sell the loans, and that's what their burden is to show. The point of the undertaking, Your Honor, is to compensate the appellants for any potential damages that they might suffer. Mm-hmm. They have put forth no evidence to show that there are actual damages other than the theoretical damages of not being able to sell the loan. And the reason for the need for a continued injunction, as Your Honors noted, is because this isn't an idle threat. Even while this injunction was in place, appellants moved in the underlying mortgage foreclosure action to try and alienate the loans through proceeding with a foreclosure, which again would completely undermine the point of the LPSA, which was not only to acquire the loans, but also to allow respondent to go in, settle these litigations.
Doesn't that undermine your previous point? I mean, that shows an opportunity cost by not being able to sell the loan. I mean, they've been sitting there on these loans for a while now, and they may want to sell them to someone else. You guys were going to buy them for $100 million, right? So that means they're worth something. So that's a year of not being able to sell it. There's the they're missing out on the VIG, like they're not getting the money they could get. And probably there's some transaction costs involved in monitoring the loans. I don't know. I mean, I can imagine. So why not a undertaking?
Well, a nominal undertaking would perhaps be appropriate, but again, there's no evidence that they actually have the ability to sell these loans or that they've actually missed out on.
Is there any showing that you have the ability to purchase these loans? I mean, your complaint sought a 90-day extension of the time to close, which has long since passed, and monetary damages and money damages. So as Judge Moulton said earlier, you didn't sue for specific performance. So what's happening here?
Your Honor, right now, the status quo is frozen as of October 24th, 2023, which is when we filed the complaint, because when appellants breached the LPSA, what they did was completely undermine the value proposition of the loan and make it exceedingly difficult for us to do exactly what we intended to do, which was go into the underlying litigations, seek potential settlements, and then move
You
forward.
make that point very well in your briefs, but wouldn't that just imply money damages and therefore not injunctive relief, or no injunctive relief is necessary? You
No,
got a
Your
breach of
Honor.
contract claim. Yeah, just evaluation, it's hard to come up with a valuation, I gather.
It's not only hard to come up with a valuation, which itself constitutes irreparable harm, but this court has also held in cases like Bass versus WV Preservation Partners, which we cite in our brief, that the loss of an exclusive opportunity to purchase the loans can itself constitute irreparable harm.
What about,
I'm sorry.
please?
Wasn't a component of the LPSA was for the plaintiff to eventually get involved with potential development of the site? The building was a key component, not just buying the loans, but the property. That's why injunctions are usually granted. You want to preserve it so they be able to deal with it later, correct?
That's absolutely correct, Your Honor, and there's no question, if you look at the LPSA, there are no fewer than 8 separate sections within the LPSA that deal with exactly that issue. Who has the right to settle? When do they have the right to settle? Who has the right to direct what's going on? What happens if, after we settle the loans and acquire the property, we move forward with the development? There's actually a profit sharing requirement in the event that we move forward and develop the property. And so to say that this is just about the purchase of loans is misleading, because the heart of this contract, as the Supreme Court correctly noted, was always not just the purchase of the loans, but also the ability to go in, settle the underlying actions, and move forward with the property. And Your Honor, if I could just make one other point on the unjust enrichment point. Putting aside the fact that we're at the pleading stage and we have the absolute right to plead in the alternative, there is a question here about whether the contract applies or not, because according to appellants, they were completely within their rights and nothing they did violated the contract. We obviously disagree with that, but this court had held that it's not just whether there's a contract or not, it's the question of whether the contract applies to the causes of action at issue. And in our view, even if they're right that they were within their rights under the contract, they've been enriched by this $6 million of deposits that they continue to hold and have held now for more than 2 years.
Counsel, let me stop you, because isn't that the same as a breach of contract? You put down $6 million, and your breach of contract cause of action is seeking redress for the $6 million, and the unjust enrichment is the same allegation, same factual allegation, the same damages. What is different between unjust enrichment and the breach of contract causes of action?
I see my time has expired, Your Honor. If I
Please.
could- Your Honor, because the reason it's relevant, not just because we're at the pleading stage and we're pleading in the alternative, but if appellants are right that they did not breach the contract.
So what facts are different and what damages are different that would give rise to unjust enrichment? The case law is very clear. If they're combined, then you can't have 2 causes of action for the same relief. So what is different? Because I haven't seen any, I know that's the pleading stage, you haven't articulated any alleged facts or even damages that would give rise to unjust enrichment.
Your Honor, it's not about the facts of the underlying action, it's about the import of those facts and whether or not they actually breached the agreement.
Are you admitting it's the same facts?
The same actions, but I think the interpretation is what we would rest on. Thank you, Your Honor.
Thank you, counsel. Can you just address that point, or one of the points he just made, which is that they have, at all points of this transaction, said that they're going to develop the building, and it's real estate, and real estate is unique, and so that's a reason for a preliminary injunction.
Yeah, certainly, I would address that. The underlying contract, as we said in our papers, and I'd like to reiterate, was about the purchase of the loans themselves. This was a sophisticated, a very, very highly sophisticated contract that was entered into by sophisticated parties that were represented by counsel. If the respondent wanted additional provisions that expressly provided that the appellants would assist them in the ultimate aim of acquiring the property using the loans, then those are terms that should have been expressly set forth in the LPSA. The LPSA does not make those representations. Indeed, it says the exact opposite. 2.1 of the LPSA contains a disclaimer, a fairly extensive disclaimer, in which the appellants disclaim numerous things about the actual loans that they are selling. as part of that, one of the things that they disclaim is collectability, merchantability, the actual ability to actually collect under the loans themselves. So the two things stand in diametric opposition. You cannot say,
Counsel,
certainly.
You're not really answering the question because.
Oh, I'm sorry.
I understand that there's no guarantee on collection, but weren't there several provisions in the agreement which essentially they would step into the shoes in order to do certain things, and you were prohibited even to saying certain things? While it may not be expressed, it was certainly implied that their intention, it's all over the agreement, and I don't think anyone has contradicted that the whole purpose, even in the mediation, was to get in there. And as a matter of fact, the reason we have the case is because it went too far, and so why isn't there a necessity to just keep everything in place while the action continues?
There are a lot of things there, so I'll try not to answer this as best as I can.
I couldn't hear you.
I'm sorry. There are a lot of things as part of your question, so I'll try to answer as best I can. Sorry, my voice is giving out. With regard to holding things in place, what we're talking about, I assume, is the preliminary injunction. The balancing of the equities is relevant because at this point, the person who actually owns the property, the loans themselves, is the appellants. The appellants have held on to the loans for, as Judge Kapnick identified, for over 2 years, and are being harmed on a daily basis because there is an actual carrying cost that's associated with holding on to the loans.
So that would be a necessity for an undertaking, is that
There's a
correct?
necessity for an undertaking, certainly, because, and I take issue, not take issue, but I wanted to respond, obviously, to the respondent's point that there is no evidence of damages. Every single day that the appellants continue to hold the loans, the underlying real estate accrues costs which are not being paid, which are accruing to the people who are trying to protect their interest in the secured property. That happens on a daily basis. It is continuing harm. There is clearly evidence that they're an undertaking that exists. With regards to holding things in amber, we believe, as I said before, that the bankruptcy court order said that the LPSA expired. And to the extent that it expired, they can sue for money damages in this court. And whatever damage or harm they can prove at trial, they could obtain in a money judgment, but they cannot obtain the property because they could never close under the LPSA. Thank you very much.
Thank you all. Next case is Bordenaro v. E.C. Provini et al.
Good afternoon. May it please the court. Jason Meneses for defendants, appellants, and third-party plaintiff, appellant, respondents. E.C. Provini, Bath and Body Works, L Brand Store Design and Construction, L Brands Inc., 441 Lexington and Gordon Property. This is an appeal from the denial of defendant's motion for summary judgment seeking dismissal of plaintiff's complaint, including the Labor Law 240, subsection 1, 241-6.
Yeah, let's start there. I don't know, there's a couple cases out of this department, Schorndorf and McGregor, that both, I think, deal with the same kind of jack that's used here, and the similar issues about whether there was enough room to maneuver with the jack and it was a proper safety device.
So I think Schoendorf is distinguishable because in this instance, the plaintiff, in Schoendorf rather, the item that they are trying to remove using the jack dips off the jack. And the plaintiff is injured when he's trying to lift that elevator platform, which is, I believe, what was on the jack, back onto the pallet jack. And at that point, he feels a snap in his left arm.
Right.
In this instance, that's not what happened here, right? The plaintiff is moving the cabinetry from the front of the truck to the lift gate, lateral movement, back to front. Right?
Yeah, but it's also like parking a car almost. It's not entirely lateral. It's like he had to move it so it was the length matched the length of the part of the truck that, I forget the name of
the lift gate. Understood, Your Honor. But the issue is that the cabinetry did not fall on the plaintiff, right? It didn't strike him. I know.
he said it pushed him, so that's the issue of fact. It seems like. I mean, so if it pushed him, was that the force of gravity? You say no.
I say no, based on Topher, and I think Topher is very similar to the facts in this case, right? In Topher, plaintiff and another coworker were unloading large steel beams from the back of a flatbed truck, and they're using wooden levers in order to actually push the beams off the truck in that case. And one of the wooden levers for some reason, strikes the plaintiff in the head and knocks him off the
But it
tractor
kind of
trailer.
struck back at him almost like some kind of lever. So that was, I think Topher could be distinguished by saying that was a vertical push and not gravity, but rather, the creation of some energy from using the levers against the steel beams.
Right. So when the lever strikes him, he moves. He gets pushed either back or upward, and then he falls off the truck.
Right.
Here, plaintiff, if we take what plaintiff says as true, right, that as he's moving the cabinetry, it pushes him backwards, right? How is that distinguishable from Topher, right? It's lateral movement that comes into contact with the plaintiff, which then causes him to fall from the back of a truck.
Now, Topher was pre-runner, right?
Yes, Your Honor.
So does that matter?
So runner's not relevant here, and I think there's a very important distinction as to why runner doesn't apply. So, right, in runner, the essential question is whether there's a force of gravity acting on a load that is descending, and in this instance, the cabinetry was not in descent. Right, in runner, the plaintiff and his coworkers are using a pulley system essentially to lower an 800-pound reel of wire down a flight of stairs, and the plaintiff is then pulled laterally and he injures his hands, right? Here, the cabinetry was not in descent when the accident occurred, so it's our position that there's no force of gravity on the load, right? There's no force of gravity on the cabinet that causes this accident. So that's why we think runner is completely distinguishable. And Walensky is distinguishable for a very similar reason, right? Walensky deals with the issue of the same level rule. He's standing there and some pipes fall on top of him and they topple over, right? Again, that's a clear falling object case. That's not what we have here. So we think the lower court erred in applying the force of gravity test. We think the court erred in holding essentially that runner is applicable to the facts of this case. And we think that Topher very clearly establishes why this case is not a 240 case.
The plaintiff fell off the truck, right?
is correct.
After this happened.
That is
and
correct.
The pallet jack was supposed to carry at least, be able to carry at least 2,000 pounds, and this piece of cabinetry was supposed to be about 1,000 pounds.
That's
Should have
correct.
been okay, and he's moving, and somehow there's some kind of push, and then he falls off. So, I mean, I don't think there's any two cases I've ever read in all my years of many, many labor law cases that are exactly the same. Everything's a little bit different, and which is why labor law lawyers can spend their entire lives and our entire lives hearing all these cases up to the appellate division and the Court of Appeals. But, I mean, if there's some type of an elevation differential, which there was, and that's what Walensky and Runner talk about. It's something that we have to consider. And they're using this pallet jack, and there's at least an issue of fact as to whether this pallet jack was appropriate for what he was doing, because he got injured and fell off the truck.
Well, I disagree, Your Honor, and I think we can look to Patang versus the Beacon Broadway Company, where the plaintiff falls 4 feet off the back of a flatbed truck, and that was a case decided by this court. This court held in that case that it was not a gravity-related accident contemplated by the statute. A very similar situation,
Counsel,
a fall from a
can I
truck.
stop you? Because the facts really bear out what transpired. You argue in your papers this is a falling worker case rather than a falling object case. But let me just read you some testimony from the plaintiff on page 219. I'll read you the answer. And we're talking about, they asked what happened in terms of the sequence of events. So the answer on line 10 is, what happened first? It just started pulling on its own. And I was pushed off the left side of the lift, and my foot got stuck, and I went off. So isn't that gravity related? Isn't the argument that this 1,000-pound object pushed him off the truck, and why is that not similar to Runner rather than Topher, which was a falling worker situation?
So, because in this case, this is a falling worker case, right? It's the movement of the cabinetry, again, is horizontal or lateral movement. It's not vertical movement. They're not in the process of moving the cabinetry, let's say, down a flight of stairs the way they were moving a reel of wire in Runner, right? It's Topher, where an object strikes the plaintiff in a lateral fashion and causes him to fall. That's what happened here, and that's the testimony. So it's our position that Topher is applicable. It's not stale or old or overturned, and there's case law, there's cases that are coming out now in 2024 and 2025 that are reaffirming the findings in Topher.
Thank you, counsel. You have time in rebuttal.
Okay, thank you, Your Honor.
CBI.
Good afternoon, Your Honors. Matthew Cuter from Lewis, Brisbois, Bisgard, and Smith for CBI Drywall. I'm aligned with counsel on the 240 issue. We have slightly different analysis on the 241-6 issue. I believe.
You want to talk about 241?
Yeah, sure. Well, counsel didn't have an opportunity, so I might as well hop in and bat that a little bit.
And there we're talking about the industrial code sections that the judge below found did apply. Why do they not apply?
So the judge below found the 3 sections that potentially could apply. 6.1D, that requires that equipment not be overloaded. As Your Honor mentioned earlier, this equipment was rated between 2,000 or 5,000 pounds. Plaintiff was shown an exemplar which was slightly smaller than the one he used, and that one was rated for 3,300 pounds. The load on this piece of equipment was estimated to be 1,000 pounds. So that piece of equipment was able to hold that load. So that's why that section does not apply. 9.8D, that requires an automatic device to allow things to be lifted up on a pallet truck. I'm going to leave aside the pallet truck issue and whether or not this pump jack is a pallet truck, but the testimony is clear that this device had an automatic device to pump it up. Plaintiff testified that he pumped it up 4 inches and then he moved it laterally. The last one, 9.8E, that concerns the levelness of surfaces.
Right. There was no testimony about misleveling of the lift on the truck in this case, right?
There is a suggestion from plaintiff that potentially the lift gate was sagging from the level of the truck, but that was speculation from plaintiff. The load on the pallet jack stayed securely fastened regardless. And I'll just also raise my particular issue with that industrial code provision. That has nothing to do with my client because my client did not own the truck. If anything, it's the delivery truck's problem. And
Your contractual indemnification clause is fairly broad. It just says anything that arises from your work, at least vis-a-vis the general contractor. That's correct? I mean,
yes, Your Honor, that's correct. But with respect to the industrial code provisions,
okay.
The condition of the delivery truck does not arise from my work. If Your Honors were to find some sort of issue of fact on the Labor Law 240, subsection 1 case, a gravity-related issue, I would concede that likely a decisive ruling on the contractual indemnity issue would be premature, if there's a question of fact on that issue alone. But if you leave that, if you take that issue aside and everything else is just negligence, and the plaintiff is not able to recover for his negligence, E.C. Bravini is not able to be indemnified for their negligence, and therefore the third-party claims should be dismissed, should Your Honors rule that there is no viable Labor Law 240 case. I'll briefly just touch on the contribution and common law indemnity cases. No one argues that those shouldn't be dismissed.
Oh, no grave injury here.
No grave injury, correct, Your Honor. On the breach of contract for failure to procure insurance, my client did procure insurance. It's undisputed that we procured proper insurance.
Premature whether they would potentially read excess. It was premature to seek it right now. That's essentially the position right now. You procured insurance.
I procured it, yeah.
The issue of whether they would exceed the primary and hit into the excess, we don't know any of that yet, right?
Yeah, that's a carrier-on-carrier issue. My client obtained proper insurance, so that cause of action should be dismissed. Unless Your Honors have further questions for me, I'll rest on my papers.
Thank you, counsel.
Thank you, Your Honors.
Good morning, David Strano from Montiel Strano for the plaintiff respondent, Stephen Bordenero. I would just suggest that the appeal was, the motion below was well set forth, and the judge wrote a very clean decision on it. Here you have a situation with a worker who's actually asking for a safety device. He says, I need this safety device. We're moving something from one level to another. The fact that it's the back of a truck shouldn't make a difference. They're moving something from 4 feet of height down to another level. He says, give us a forklift. Everybody agrees. My client, their client, his client.
And he asked for a forklift more than once, right?
Several times he asked for it, and they've done many jobs before that where they had a forklift. And the only reason it wasn't given a forklift, is because it's the money issue. I mean, we can.
Well, they had another excuse, but
Well, they said it was logistics. Logistics equals money. That's what they were talking about. They didn't want to spend the
they
money
said they
to buy
couldn't
it.
store it. I thought they said that rather explicitly. There was no room to store it at the site. But I know you also have an argument that it was.
Well, they could have rented it. They could have rented it for a day. You could go on your phone right now, and we can get one here in 20 minutes.
Because CBI did not have the right union member who could run a forklift, and so you'd have to hire another trade, right?
Yeah, there was apparently a union issues where CBI was unable to get a forklift down there. It would have to go through the GC. The GC acknowledges that. He says it, it's testimony. If there's a forklift on the job, it was going to be me. He says, if I could have had it there, but for this logistical issue, I would have had it there. They all agree it would have been safer. They all talk about how this job could have been done more safely with a forklift. He actually testified.
Let's put the forklift issue aside for a moment. Let's talk about the gravity-related issue.
Yes.
I mean, his testimony is a little bit equivocal, isn't it? I mean, he said he never saw the cabinetry on the pallet jack shift, quote unquote.
Well,
He did say something about a push, but I mean,
They're
is that
moving.
enough?
I thought the testimony was pretty clear. They're moving this gigantic piece of cabinetry off the back of a truck, and they've got to swing it sideways so it fits exactly on something like half the size of this table.
Well, the lift gate is about 8 feet, and the
8 feet.
cabinetry is about 8 feet, and it's got to be lined at just so.
It's got to fit right there, right on that exact size. So they have to spin it a certain way. As they're starting to spin this thing weighs 1,000 pounds or more. It starts to move, and here he is on the truck, and he's pushing him, and it goes over, and then it knocks him over, and he falls 4 feet. It's a gravity case. He falls. He's injured because of falling 4 feet.
Does it matter that he was working with another coworker who was actually pushing on that piece of furniture?
I don't think it affects. I don't think it affects the case one way or the other. There's two workers moving. They needed two workers to do it. They would have only needed one worker if they would have got the forklift like they should have gotten in the first place. So I don't think it hurts the case that there was somebody else assisting with that. That guy's lucky he didn't get hurt as well. But so I don't see any issue as far as that's concerned.
Could they have provided him with some other some other device other than a forklift that would have helped him do the job as opposed to this pallet jack?
Well, CBI's own workers talk about they brought their the things he was moving at the time of the accident were materials supplied by the owner. They supplied their own sheetrock. When they brought their sheetrock to the job, they brought it on a spider truck. A spider truck's a flatbed with a thing that hangs over it. You pull it off, and nobody gets hurt. They decide, I should say, E.C. Perini, these are the trucks, this is what we're using. Can I get a forklift? No, just go do the job. So, yes is the answer, is the short answer, I guess. They could use the spider. Also, they could secure the load, make sure it's not going to fall off, tie it off in the truck so it doesn't fly out the back and land on somebody, and none of this was done.
So if Pravini says, I have nothing to do with the way he's bringing out the things from the truck, would they have any liability then if they're not involved in the way that he's bringing out, unloading that truck?
I agree they say that, but I don't think that's the case. The fact of the matter is that there's a meeting, and it's talked about, several meetings. We need a forklift to get this off the truck. You can't do it. Go do the job. Here you go. Here's a pallet jack. I mean, that's the clearest case control you can have. He's literally telling them, this is the machinery that you can have and you can't have. You have a guy asking for it. Can I have a forklift? No, you can't have it. Go do the job. That's control of the job. What else could there be? But what more control can you have than somebody saying, you know what? These are the tools you're going to use. Do it and get it done with.
Before you leave, I want you to address Topher because I want to give you a chance to do so. You heard your worthy colleague state that Topher precludes this type of situation because it was a lateral movement, and this is not a type of gravity-related injury that would give rise to liability. How do you answer that?
Well, I answered that Runner and Walensky aren't talking about lateral movements and up and down movements. What they talk about is the risk that's related to a gravity-related situation. This gentleman is working, he's moving something from one level to another. He's going to be on the edge. If he was up on the third floor and he fell off, it wouldn't even be a question. The fact that he's on the truck is the only reason that we have these questions.
Are you saying Topher is no longer good law?
I'm not saying Topher is no longer good law, but...
How do you distinguish it?
Well, because Topher, the way that Topher had been used was to say it's only a short distance, it's only a small distance. That's not the way Runner and Walensky follow the law anymore. What Runner and Walensky said is that you have to look at the totality of the circumstances, what's going on at the time of the accident, and is somebody in peril from a gravity-related danger?
Can you address lateral movement? Because that was the last comment that your colleague stated. Since it was lateral movement, there is no such thing as gravity-related because it's lateral rather than vertical.
Well, he falls off the truck, so that's gravity. That's the simplest argument is right there. He's falling 4 feet. You know, the reason why he fell 4 feet.
He fell off the truck 4 feet too.
But in Topher, they found that they were not responsible because it was a truck, because it was only a small distance. They said that distance wasn't enough. That's not the law anymore. Those cases don't exist anymore.
You're saying Topher is no longer good law.
I'm saying the way that Topher was applied then is certainly not the way it's applied now. That's certainly the case.
Counsel, before you sit down, we got Labor Law 200, which we haven't talked about yet, but would you agree that Labor Law 200 and common law negligence track each other? So, because the court below seemed to omit any reference to common law negligence, so there wouldn't be a possibility of a common law negligence claim surviving if a Labor Law 200 claim does not survive, right? They track each other.
Well, it's the same thing, yeah, it's common law, but he does show control of the work.
Well, I know that you have an argument that, and they have arguments about who's might be on the hook for Labor Law 200. All I'm saying, is there any daylight between the common law negligence claim and Labor Law 200 that you can articulate?
That I can articulate? Probably not, but there might be some daylight there.
Okay, let's leave it at probably not.
Okay.
Okay, thank you very much.
Very well.
Just very briefly, I do want to touch on the common law negligence against E.C. Provini. The idea that E.C. Provini just didn't want to spend the money and just put these workers in peril is just, it's belied by the record evidence, right? The load rating of the floor inside the building could not withstand the weight of a forklift. So had a forklift been provided, putting aside all the logistical issues, if someone drove the forklift unknowingly into the building and fell through the floor, we'd be having I guess almost a very similar, maybe a worse conversation about this.
Wasn't there some other type of device that you could have provided the plaintiff to assist them in unloading that truck, other than this pallet jack or a forklift?
Not that I'm aware of, and not that came out in the testimony that's on the record. At the end of the day, Butch Hardy, the E.C. Provini foreman, literally removed the exact load that the plaintiff was attempting to remove when he got hurt without issue. 10 minutes after. He got on, he spun it the right way, got onto the ground, and everyone went about their day. The plaintiff's inability or failure, I guess, to remove it the correct way doesn't necessarily...
That's comparative negligence, right?
I understand that, yes. I guess my point is that there's evidence in the record to demonstrate that the pallet jack was sufficient to perform the work because the work was done correctly and it was completed using the very devices provided to the plaintiff.
Counsel, can I ask you about lateral movement? We heard discussions about it. Doesn't Schoendorf state that, I have the case in front of me, there was a 400-pound elevator platform was being moved from the front of a flatbed truck to the tailgate. Isn't that the same flat surface that we have here? And in Schoendorf, they granted summary judgment?
So there's a distinction in Schoendorf and here, and it's how the accident happens. In Schoendorf, they're moving a 400-pound elevator platform, and the plaintiff's injury happens when he's trying to lift up the elevator platform that was sagging off of the pallet jack. He feels a snap in his arm.
Why? Because that was the force of gravity, correct? It's a runner-type case. Isn't this the same? He was lifting, he was trying to maintain the the cabinet from hitting him, and then taking it off, and the force of gravity pushed him off the truck.
I think there's a distinction between trying to lift something that weighs 400 pounds and feeling a snap in your arm, and a coworker moving a cabinet back to front laterally, which then bumps you and knocks you off.
Wasn't the jack lifting it? Isn't that the same thing? He's just using an instrument to lift it. If you use your physical hands or use an instrument, isn't the same lifting?
I
What's
would
the
say no,
distinction?
right? Because the pallet jack is used to lift heavy objects, whereas someone's hands might not be adequate to lift something that weighs 400 to 500 pounds.
So it seems that it may not be adequate using that device. You're making the case for summary judgment. You're saying that the item was not sufficient to lift it.
I disagree with that, Your Honor. I'm making the argument that the pallet jack was sufficient. The issue was not, could it be lifted to be removed off the truck? That's not the issue. There's no claim that the pallet jack couldn't pump up the load that was ultimately being removed. The issue.
It's lifted and moved. Isn't that correct?
Yes, but I guess I'm not understanding the question. Perhaps.
Let me start again. Schoendorf. Schoendorf required the force of gravity of a 400-pound elevator platform on a flatbed truck. Here, the cabinet was the same flatbed truck, and it was 1,000 pounds. So what's the difference between the force of gravity in Schoendorf versus the force of gravity, which would have been greater if it was 2.5 times the weight?
The mechanism of the accident, I think, is what distinguishes this case from Schoendorf.
Thank you, counsel.
Thank you. Appreciate it.
CBI has 2 more minutes.
Yeah. Yeah.
Running out of here.
Do you have anything to comment on the contractual indemnification between you as the, anything else between you as the, I mean, he didn't have any chance to discuss it, so do you have anything else to say about that?
On the contractual indemnification issue, EC Bravini is not EC Bravini was the trade here that had the decision-making authority regarding whether or not to have a forklift on this project. If this court credits plaintiff's theory that a forklift should have been there, that is negligence on EC Bravini, and that would preclude any finding in their favor on the contractual indemnification case. Where there's a specific...
Even if there's a saving clause in the particular provision, so if EC Bravini was negligent in part, then there still can be an allocation of fault pursuant to that indemnification clause between CBI and EC Bravini.
There's also the possibility that a jury could find that EC Bravini was the only negligent party in this matter. I want to talk briefly about Schoendorf a little bit. I might be stepping into it, but who knows? My understanding of the Schoendorf case was that that 400-pound thing that was on, it was actually sagging off. So the piece of equipment in that particular case was not adequate to keep that 400-pound piece of equipment on it. So that was the argument there for why that particular piece of equipment was not adequate, because the thing they were trying to move was sacking off. In this particular situation, everything was firmly secured onto that pallet jack. I do also want to briefly touch on one thing that plaintiff counsel mentioned. Regardless of whether or not a forklift would have been used here, a pallet jack would have also been used. The forklift would have been used from the ground. It would have had the forks up, elevated, and they would have taken it from the back of the truck like that. You still need the pallet jack to maneuver the equipment inside the box truck towards the back of the truck. So this isn't like a one or the other situation. It's either pallet jack or pallet jack plus forklift. I just wanted to clarify that factual issue. Unless there's anything else.
Thank you very much.
Thank you, Your Honor.
Thank you.
Can't respond to that? No.
RSD 857 LLC v. Wright.
Good afternoon, Your Honors. I'm Judy Shametzi from Wilson, also for the appellant Viscusi. I respectfully request that the portion of the order that denied the portion of Viscusi's motion be granted.
Doesn't this is a pleading motion, of course, so the complaint does a very good job, I think, describing the alleged fraud here. And it seems to me that Mr. Viscusi is at least by implication knee-deep in it
Well,
because of his valuations. He didn't do comparables that were from the neighborhood, and he didn't think about the highest use of the particular lot that is in question. So doesn't that look bad, at least at the pleading stage?
lots of things look bad, but the reality is that he is not a co-conspirator already, because they did not appeal from the portion of the order which determined that whatever else may be an issue with the report, and of course I'm happy to talk about it, this whole elaborate scheme with the various goons that are involved in this horrible story, Viscusi just happens to be the guy they called to do the appraisal. There is no allegation that he has.
Who called him to do the appraisal? Was it Mr. Wright or was it someone else?
No, basically our RDS calls, the buyer calls him. And he knows that, right? Knows that he's basically being hired an appraisal. No question that the appraisal report lists him as the owner. I do want to get ahead of that. I understand that, but yes, he doesn't call them, but nor does he rely on them, which I think actually is entirely dispositive of the case, regardless of any other issue.
But the report makes it clear that it was being prepared for Mr. Wright. It's so clear.
The report does say that.
And the issue is that Mr. Wright, relying on that report and the undervaluation of the property, went ahead with the short sale.
Yes, but no, because as of September 5th, 2018, Mr. Wright signs an affidavit in opposition to the motion for summary judgment in the foreclosure action. It's not in small print. That says that he expects this to be a short sale. Just to say, he knows at that moment, and this is September 2018, he knows then, this is page 555 of the record, and I do think it is entirely dispositive of the reliance issue. At that moment, his expectation—
Counsel, but this is a failure to state a claim motion to dismiss, right? A7. So, and also, even if it was a documentary motion to dismiss, an affidavit is not a document for that purpose. So why are we talking about his affidavit in the foreclosure?
Well, Your Honor, both sides introduced a number of documents that were not traditionally speaking materials that you would see on a motion to dismiss. Among them, for example, the appraisal. It's not even a counter appraisal report so much as a critique of the appraisal, because it doesn't actually value the property, which I thought was odd. But
okay.
My point is only that you have to, and there's no question, even on the complaint's own recitation, there's no question that Wright has signed sales contracts prior to getting the appraisal, and all of those, these for five.
But they didn't go through, right?
They didn't go through, but my point is that he is expecting this to be a short sale. So in order
Did he know at the time what the appraised value? He had no idea what the appraised value was at the time.
What he expected was a short sale, and I think he has 1.7 outstanding on his loan, and what he expects is to have a short sale, and he has that expectation signing a sales contract.
And that excuses the misleading appraisal that Mr. Viscusi obtains or puts together, which clearly was not based on comparables, comparable property. I mean, how does one, I mean, this is just a pleading motion. How does one, excuse him completely from this case?
Well, it's an entirely different element of the claim. So I do think that that Viscusi's appraisal does not hit the level of, no matter in whose formulation, doesn't hit the level of error
Counsel,
that would
can I
qualify it.
quantify it? Isn't it true that the valuation was 3 to 4 times less than the average price of comparable 2 and 4 families, and vacant land, it was even more? It was approximately about $2 million versus $825, and about $4 million for vacant land?
There were sales in the area, Your Honor, for those numbers. What is interesting about them being comparable, though, is the portion of Viscusi's report that Wright takes absolutely no issue with, which is not only was this going to have to be a gut renovation, it is not up to code, but there's issues with the foundation of this house, which is all in his report, which is maybe the one part of their critique that it absolutely acknowledges. There is mold, Nothing is up to code. The electricity is not up to code. This is going to be a gut reno, and you're going to have to reinforce your foundation. So as far as comparability, Your Honor, this house is in pretty severe trouble at the point where he is appraising it.
Didn't the other expert call it exorbitant discrepancy?
He did say that, Your Honor, but again, he doesn't actually appraise. He says it was low. I know that he does, but he doesn't say how much. There is no discussion. There are pictures which I think are telling, just of the outsides of the comparable sales and of this house. They are clearly not in any kind of remotely comparable condition looking at it from the outside. But again, this is the misrepresentation element of the fraud.
Thank you, oh, please, go ahead, please.
Counsel, I just want to clear one little thing. I will concede that he wanted to do a short sale. Let's concede that. So let's look at dates. The appraisal date, as I understand it, was January 18, 2019. The sale was October 2019. The appraisal was prepared for Mr. Wright. Very clear it was for Mr. Wright. So Mr. Wright, an elderly, legally blind person with ordinary intelligence, is looking and relying on the expertise of your client, which says $825,000 value, and then he proceeds with the sale. And given that this is the pleading stage, as our colleagues have pointed out here, isn't this enough to say that he relied on this appraisal report to his detriment, and therefore we should move forward?
It's the detriment part, Your Honor, where as a matter of law, it cannot be so. He knew before the appraisal, and he was on the course before the appraisal to sell this house in a short sale. He does not alter that course as a result of the appraisal, which is to say he gets this information that is alleged to be fraudulent, and I don't think that it hits that threshold, but for purposes of this, let's assume that it does. He stays exactly on the course that he was already on. He does not alter his course in reliance
We take
on
the point,
this
counsel.
report.
You made it pretty well. Thank you.
Good afternoon. Jessica Hood on behalf of Respondent Albert Wright. I want to respond to 3 points that were just raised. The first is the civil conspiracy claim, the second is the reliance claim, and the third is the suggestion of all the gut renovation stuff with respect to material misstatement. I'm going to take them in reverse order because I think that that's kind of the simplest way to go. All the arguments about gut renovation, this was raised for the first time in this argument. It's not in the opening brief, it's not in the reply brief, it was not raised below. This court should not reach that issue. With respect to civil conspiracy, apologies, taking it slightly out of order, Viscusi grossly misreads the district court or the trial court order. The trial court dismissed the claim of civil conspiracy for a pleading failure to allege an agreement. That is an element of civil conspiracy, but not an element of fraud. Plaintiff improperly tries to turn this dismissal for a pleading deficiency into a factual finding, highly inappropriate on a motion to dismiss. In any case, Viscusi didn't move, and the trial court did not sua sponte strike the allegations, such as pursuant to CPLR 3024. This court has repeatedly explained, such as in Parker versus Trustees and Spence Schools, that allegations relevant to a dismissed claim can still be relevant to a not dismissed claim. The counterclaims here clearly allege a relationship between Viscusi and Petrokansky, one that Viscusi does not deny. In their opening brief, they concede that the appraisal was commissioned by Petrokansky. As alleged in the complaint, Record on Appeal 86, Viscusi agreed to undervalue the premises, and Viscusi was aware that the premises could have been used as a development site. At the motion to dismiss stage, that is more than enough. Viscusi's portrayal of himself as having absolutely nothing to do with the scam is counterfactual and not consistent with the allegations in the complaint, which must be taken as true. Now turning to reliance, which Viscusi appears to believe is his strongest argument. The crux of their argument, at least today, has been that Wright already agreed to sell. I have two responses to that. The first is that is, again, inconsistent with the allegations in the counterclaim, which, again, must be taken as true at this stage in the proceedings. As alleged in the counterclaims, Wright alleged that he would not have agreed to a short sale if he knew the true value of the premises.
What about counsel's statement a few times that he had signed a document that said that he was aware that he was entering to a short sale, and that's what he was anticipating was going to happen here?
3 responses to that. The first is that What was the point of the appraisal at all if he had already agreed? If Wright had agreed to a sale, why would an appraisal be necessary? The second is that the closeness in time and the closeness in price. The 3 or 2, however you want to look at it, previous memorandum of contract, nobody is saying that this is a contract, occurred 1.5 years before the actual sale of the property, versus the appraisal and the actual sale of the property, which occurred with only a 10-month difference. And the price at which the purchase occurred was nearly identical to the appraisal itself. But more importantly, neither Petrokansky nor Wright, the parties to all these various memorandum of contract, suggest that these are sales. At page 27 of the record on appeal, that's at a court conference in the foreclosure action on March 2019, after the appraisal and before the formal termination of these memorandum of contract, the court acknowledged for at least the past year a short sale was discussed. Both Wright and Petrokansky agreed. Neither suggested that a short sale had completed, neither suggests that any terms of the short sale had been agreed upon. There is no indication anywhere in the record that a sale has occurred. Rather, there was clearly something missing: price, which is why the appraisal was necessary. At best, all of the arguments raised by Viscusi raise factual disputes that are not appropriately resolved on a motion to dismiss. The New York Court of Appeals said in CPC International, when you have multiple competing events and the question is just which one was the ultimate event that was relied upon, that is a question of fact, not appropriately resolved at a motion to dismiss. Unless the court has further questions, we rest on our briefs.
Thank you, counsel.
The appraisal was actually most useful for the bank because it was always going to be, Wright knew this going in. Again, this is where he is as of September. This is going to be a short sale. He's not going to get money for the house. So he is looking to be able to be walking away from the house. So the money is actually about how, and that's what the dispute, by the way, in the court proceedings is about, is how are we going to sort it out with the bank? How much are they going to take in full satisfaction for the $1.7 million that's outstanding on the loan? So that's actually the most useful part and technically useful in moving the proceedings along for the appraisal. But let me say about the pleading deficiency with respect to the conspiracy claim is the reason there's a pleading deficiency is because it is impossible on the facts that you can in good faith allege to claim that there was any relationship other than the fact that, yes, he hired him to do the appraisal, but he is not one of his goons. He is not one of these people who lives in the house and he knows, none of that. He is not in any of that. He just happens to call him to do the appraisal for $1,000, which he does. It is a limited appraisal. He says exactly in the scope of work what he's going to do, and he does exactly those things. And while we can disagree about which comparable sales he is supposed to use, the fact is that it doesn't come anywhere near a gross negligence threshold, which is what you need for this to qualify as a fraudulent statement. You can do a terrible, not I'm saying he did, but you can do a terrible appraisal so long as you're not doing it with the kind of intent that would, for example, be present in a gross negligence type of case. That's not, the question there is not how big is your error, it is what is the nature of it. He may have selected the wrong sales, but he said which ones they are. He said where they are. He accurately wrote down the sales prices of those. There is no lie here. There may be an error in judgment, but that simply does not, as a matter of law, raise it to the level that it would qualify as fraud. All of which I think is secondary to the fact that there simply is no detrimental reliance in that Wright's situation doesn't get worse because of the appraisal. He is doing exactly what he had expected as of the prior September to do.
Thank you, counsel.
Thank you, Your
both.
Honors.
Zepsa Industries v. 401 West Property.
Good afternoon, Your Honors, and may it please the Court. Amanda Gillio on behalf of Appellant Zepsa Industries. By the very terms of the statute, a motion for leave to amend, especially an initial motion for leave to amend that occurs pre-discovery, should be freely granted. And this Court has gone even further, unequivocally stating that the legal sufficiency or merits of a proposed amendment to a pleading—
So am I correct in understanding that you have the proposed amended complaint, which you submitted on your motion to amend, included a cause of action for breach of contract, Are you saying now that you don't plan to go ahead with the breach of contract cause of action? What you're really looking to go ahead with is the quantum merit and the quasi-contract causes of action?
Well, Your Honor, we're pursuing our breach of contract claim against the general contractor, Vector. Vector has responded and
Right.
answered the complaint. to
They
that
haven't
effect.
answered yet.
They have answered, Your
they
Honor,
have.
but they have not moved to dismiss. They simply submitted an answer. And as to the owner of the property, 401 West and Waynebridge, we propose both adding Waynebridge Capital as a defendant in light of the evidence that the partners of 401 West operated through Waynebridge Capital email accounts and corresponding about.
And that's why you wanted to add the other defendant?
Yes, that's exactly why, Your Honor. And so our claims against the owner focus on quantum merit and quasi-contract bases because we recognize that they are not a signatory to the subcontract.
And can you explain to me what is a cause of action for equitable adjustment? I never heard of it, and I can't seem to find any. I mean, I understand in some of the contracts there might be provisions for you to obtain an equitable adjustment, but how is that a cause of action?
Well, Your Honor, it's exactly that. It's a cause of, from what I understand, Your Honor.
I thought it could be relief that you could get under quasi-contractual quantum merit causes of action, but not a cause of action in and of itself.
Well, yes, Your Honor. I will clarify for the court that Vector has not moved to dismiss that cause of action in this action. And what really
I know
is,
there was no discussion. It's just that, I've been sitting around, sitting here for a
Sure.
long time.
It's
I'm
from-
very unfamiliar. Don't think that's a cause of action.
To my understanding, Your Honor, it's an equitable, it is like unjust enrichment causes of action, quantum merit, quasi-contract. It is an equitable cause of action that allows for the difference in the cost of or the cost expended in completing a project to be adjusted, the contract price to be adjusted. That's my understanding, Your Honor.
Same thing as damages in your quantum merit or?
Yes, Your Honor. It would,
So
there are
be
causes of
duplicative
action in the
those-
alternative.
It would be duplicative then, if it's based on the same set of facts.
Well, Your Honor,
Well, it could be a subcategory.
I think that that's exactly right, Your Honor. Okay. Thank you. Your Honor, Your Honors, again, we maintain that our proposed amended complaint was improvidently, leave to amend our complaint with the proposed amended complaint including.
But if you had a contract with Vector, why would you be able to now name the owners in a complaint?
Well, Your Honor, there is a well-stated exception to the general rule that an owner of a property cannot be found in privity with a subcontractor where they are not a party to the contract itself. And that well-settled exception comes in when the owner agrees to pay for the performance of the subcontract.
They have agreed to pay in this case?
As we include in our proposed amended complaint, Your Honor, there are several allegations included and the actual exhibits to the complaint which demonstrate email correspondence related to proposed or prospective expected payments by the owner of the property through Mr. Kernev to our client, Mr. Zepsa. It happened repeatedly, and those allegations can be found at paragraphs, I believe it is 32 to 39 of the proposed amended complaint.
So, question, 401 is the owner of the property, correct?
It's the stated owner of the property on the prime contract that defendant has attached to its motion to motion to dismiss, Your Honor.
So how do we get to Waynebridge?
Well, Waynebridge, if you actually look at the exhibits to the complaint, the exhibits to the proposed amended complaint, I should say, and that can be found at page 388 of the record, Your Honor. You'll see that Mr. Kernev, who is representing himself on behalf of 401 West, on behalf of the owner of the property, and is corresponding about payments related to the project itself, is using a WaynebridgeCapital.com email address. It's not a 401 West email address. And I'll note that the defendants have presented no documentary evidence to
Did
suggest.
Waynebridge make separate payments from 401 West to the plaintiff?
Well, the allegations in the proposed amended complaint, Your Honor, which are what is relevant here, indicate that 401 West and Waynebridge made direct payments to Zepsa. And what we're maintaining here is that allegation.
I'm just wondering, because, I mean, having an email address, I'm not sure that's such a strong piece of evidence, but whether, does the complaint allege separate payments from Wainbridge.
Well, the complaint doesn't allege separate payments, but it does allege that both entities did make those payments, and that's paragraph 33 of the proposed amended complaint. Now, all we're saying, Your Honors, is that the motion court improvidently denied us leave to amend to include Wainbridge Capital, despite this documentary evidence, to test that allegation. We haven't commenced any discovery here. We have no, we have less evidence than we would had discovery been completed, and that's all that we're trying to do.
So you're saying that your amendment to include those parties is not palpably improper?
That's exactly what we're saying, Your Honor, and what we're also saying is that the motion court engaged in a different, higher standard of review. It improperly tested the merits of those allegations in denying leave to amend. And
Thank you, counsel. You can expand on that on reply.
Oh, my apologies, Your Honor.
Good afternoon, Your Honors. May it please the court. David Pereno for the respondent. I want to get right to the heart of the issues here. I had a whole outline prepared, but I'm going to skip it. The salient fact here, and this might not come through as well in the papers as I want it to right now, is that after the lawsuit was commenced, but before this motion for leave to amend was filed, the plaintiff's lien, which was a representation of all labor provided and materials supplied for the project, was paid in full.
They say they have other damages, though.
They released every claim as pertaining to those things. That's right. They say that there's other damages, of course. The other damages, by necessity, if they have received every dollar of payment for all the labor and materials that they have provided, by necessity, they have to be contractually based. Now, there is allegations that the standard in Clark-Fitzpatrick, which is that where there is a contract, you can't also have quantum meruit or equitable claims can be abrogated if the owner has assented to payment, right? You can then assert the quantum meruit claims. The problem for plaintiff's position is that those payments were all indisputably made. Any of the allegations they have that plaintiff assented to a payment, and you can look as to exactly what those payments that they're referring to were assented to, because it's in the record, at record 397 and 398, are the lien. So the exception that they identify is itself obliterated by virtue of the fact that that claim was paid. And that was... Yeah.
They're arguing that, well, which is what they state in their pleadings, that these claims are for delay, change orders, interest costs, and other fees.
That's right, so I want to cite something that is from Clark-Fitzpatrick, because it talks about what a quantum meruit claim is, right? It is a claim that is not, it's a legal obligation imposed in order to prevent a party's unjust enrichment. Mm-hmm. Here, my client, the owner, they would have been unjustly enriched if they received the labor and materials. Here, that cannot exist because they paid in full for all of those things. So the delays, whatever other damages that the plaintiff is asserting that they have, are not leading to some unjust enrichment to my client, which would allow for the possibility of the claims that they're seeking to amend. Because those claims cannot be adequately stated, because you have the lien waiver, then it's not palpably improper to have denied their right to do so. And that's the point here. They do have an existing lawsuit. There is no allegation whatsoever that my client assented to pay for delays. The only claims that they have in terms of what they assented to, those payments were made. Thank you, Your Honors.
Thank you.
Your Honors, excuse me, I'll respond to that point. I think that my colleague is unnecessary or improperly limiting the exception to the rule that's stated when it comes to what a quasi-contract or a quantum meruit claim is intended to do. It is intended to create an ethical or an equitable contract to the terms that they are stepping into by assenting to payment. That is exactly the scenario contemplated in East Coast Mines, which is the same relationship described here. An owner stepping into the shoes of a general contractor who executed a contract and is now subject to the terms of that contract because he assented to pay for that performance. It's not specific to each individual payment that they expressly assented to. They're assenting to the contract itself. And I think it's relevant to bring up 2 points here. First, that the conduct that was undertaken by the owner went against its own commitments in its prime contract, which specifically precluded it from engaging with the subcontractor. And that is found, I think, on page 51 of the record, A51. And the second point is that with respect to the delay damages being asserted, first of all, the amended complaint asserts that the owner participated in causing those delays. It asserts it repeatedly and expressly. Second, it also asserts that the owner negotiated terms of a subcontract amendment directly with my client related to those very delay damages that it's now seeking to improperly and inequitably avoid. That is what we're dealing with here. And again, the standard at issue is whether we pled that claim. It is not whether that claim would succeed on the merits. It is not whether that claim would necessarily succeed on a motion to dismiss. We have not had any chance to conduct any discovery whatsoever, and I think we have well surpassed our burden at this very early pre-discovery stage to state a claim. We have exhibits.
I thought that counsel said at one point during his argument that you had released all your claims against them once the foreclosure lien was dealt with. And I just wondered if you could address that.
Of course, Your Honor. In the proposed amended complaint, we acknowledge both the payment of the mechanics lien, which deals with the payments related to the actual contractual sum, not the delay, the significant, by the way, delay damages that our client has incurred by being forced to take an additional 2 years to complete this project. As pled in the proposed amended complaint, the work was intended to be completed by December 1st of 2021 and was actually completed in January of 2024. So this is substantial. And the second point I would make is that in negotiating the subcontract amendment, which dealt with those very delays, they specifically retained their right, as pled in the amended complaint, to seek delay damages at a later date. Our client wanted to complete its work, it wanted to fulfill its contractual obligations, and now it is seeking the recourse that it is well within its rights to seek from both the owner and from the general contractor.
So essentially, there was a satisfaction of roughly about $250,000, which was the mechanics thing, but you're seeking millions here.
Yes, Your Honor, we are.
Thank you.
Thank you, Your Honor.
Both. Cheziak v. Airy Tenant.
May it please the court, David Scher for the appellant. The lower court erred here in failing to grant summary judgment to the plaintiff under Section 240 because on these facts, the appellant's fall was proximately caused by the failure of a
How do
safety
you
device.
differentiate this case from Cataya?
Thank you for asking the question because we can quite easily, in my opinion. So Cutea and Nazario, similar decisions, as the court knows. Court of Appeals flipped this court in both cases. I'll note that current Chief Judge Rowan Wilson did dissent in both of those decisions, but we can distinguish them certainly nonetheless. So in Cutea, the plaintiff in that case was on a ladder and received a severe electric shock, so severe, in fact, that that plaintiff had no idea what happened. He had no memory of the accident. The plaintiff was unable to establish that the ladder he was on moved in any way. And in fact, Judge Tom's dissent laid this out, and that was adopted by the Court of Appeals. What he basically said is, look, it's just as likely that this shock was so severe that it threw the plaintiff 10, 12 feet, and it wouldn't have mattered what device was provided. In Nazario, and I'm quoting Nazario now, the court found—
Do we need expert testimony to say that about an electric shock? I know you say you minimize the electric shock here, and it wasn't that big a deal. But do we need some expert to say this is not the sort of shock that would have knocked him off the ladder? And I don't know how you would get an expert to say that, but how do you prove that up?
Sure. Well, first of all, we did in this case. We provided an affidavit of a construction expert and a professional engineer named Herbert Heller, and included in his opinion is his conclusion that this shock would not have been capable of throwing the plaintiff off of a Baker scaffold with side rails, which would have been the proper device.
We also have— Yeah, but I saw that. You cite that paragraph 9 of your expert's affidavit, I think.
Correct.
he says that, but does he qualify to say that? Or maybe it's paragraph 11, I'm sorry.
He is qualified
paragraph
on this record, I would submit, Your Honor, because on this record, we have testimony from the plaintiff that he felt a shock to his hand, so small that it didn't even make a burn mark on his hand. It didn't cause him to lose consciousness. He said he pulled his hand back, then the ladder wobbled and fell over. So I think the expert's allowed to rely on that unrebutted testimony. I'd also point out that the defense expert, let's take the worst possible favorable to our case and just accept what the defense expert, by the way, a doctor of philosophy, who's not an engineer and has no construction background. I don't know why
She
she's
cites Newton's law of physics, which is, didn't seem apropos to me, but anyway, go ahead.
Yeah, I don't think it should have been considered. Let's say she is a construction expert for a moment. Her conclusion about what happened, and I'm quoting the defense expert now, is that the plaintiff received a shock. She says electrocuted, which is the wrong word. That would mean he'd be dead, but let's just assume she was right. She says he received a shock, he pulled away from the source, then lost his balance, and then, in an effort to regain his balance, likely reached for the ladder, exerted a lateral force on it, and pulled over. That does not sound like someone who received a massive jolt of electricity and was thrown several feet such that he would have gone up and over the side rail of a Baker scaffold.
So you think that this case might be more comparable to the Daniello case, which we decided in June?
Yes, Judge, and I know, Judge Kapnick, you were on that decision. There, just to remind the rest of the panel, the worker was jolted by an unexpected drop of a ceiling tile, resulting in a, quote, wiggle of the ladder.
Which is what the words that the plaintiff used in this case, right?
I think he used a little stronger language than that, wobble, wiggle. In any event, a wiggle, in that case, in Daniello, causing a loss of balance and a fall, and this court granted 240, and I submit that there's really no way to fairly distinguish our client from Daniello. I just want to, Nazario quickly, because this whole case comes down to distinguishing Nazario and Cutea, I think. That's what we're doing here right now. And the language of Nazario is so important. I'm quoting the court in Nazario, which found an issue of fact there. Nazario said there was no evidence in that case that ladder movement caused the fall, and there was no evidence that another device would have prevented the fall. The exact opposite is true here on both counts. There is evidence that ladder movement caused the fall. There is incredible evidence that another device would have prevented the fall. We have testimony from the
What's
general
the evidence about the ladder? Just that the feet were missing, the rubber feet were missing, it was a little bit bent up? That's what you're saying?
No, I'd like the court to assume it was a perfect ladder.
Okay.
For purposes of this, so that we can win on summary judgment. Let's assume it was perfect, inherently okay, the ladder.
Okay.
A non-defective ladder. It was the wrong device, as proven by the testimony of Consigli's project manager. There's incredible deposition testimony in this case that can really distinguish this case, frankly, from just about any other. And this is the project manager from Consigli, the defendant, who testified a Baker scaffold could have fit there. And then when he was asked a question, this is William Gonzalez on the record 1046, he said, quote, "I would say it would be safer to use a Baker scaffold." So we have the GC admitting it, we have their expert not denying it, we have our construction expert with 50 years of experience, professional engineer, saying it would have prevented this fall, and given the way the plaintiff describes the incident, there's absolutely no reason to reasonably infer from this record that this is the type of shock that would have thrown this man off of a Baker scaffold. It's distinguishable from those two cases.
He didn't pass out from the shock, did he?
No.
And he remembered what happened after he was...
He remembers everything. This would be like you or I touching a metal radiator in our house and going, he pulls his hand back, loses balance, and falls. He doesn't have so much as a burn mark on his hand. This is the type of precipitating event to a ladder fall that this court has over and over again held can lead to a 240 case in the event that the ladder does in fact wobble and fall. This is not Cutea at all.
Thank you, counsel. You have time to rebuttal.
Thank you.
Please.
Good afternoon, Your Honors. May it please the court. My name is Sean Hutchinson from Cipriani and Warner for the defendants' respondents. The trial court here properly denied plaintiff's motion for summary judgment on his labor law 241 claim. Plaintiff, of course, bears the burden to establish his prima facie case for summary judgment on labor law 240 and to exclude all questions of fact.
I'm sorry. Did you say he didn't or he did?
That he had that burden.
Right, and he met it. He fell from a height-related situation, correct?
So he had the burden to exclude all questions of fact as well. And here,
What's the question of fact? He said the ladder moved and he fell.
he said that he was electrocuted. And
Right. So that's the only difference.
Well, it's
He
not.
received a shock.
I mean, there seems to be a little bit of a distinction in level between some of the cases where people were electrocuted, where I see there's one situation, or this case where, as Mr. Scherer said, he barely had a burn mark on his arm. It was just enough to sort of like this Danielle case, something that just made him pull away for a little, and then the ladder wobbled, and then he fell out. It wasn't like Kutea, where he really had a terrible electrocution situation.
in this case, Your Honor, I think this case is more applicable to, or it's more in line with what happened in the Higgins case from 2020, with regards to the degree of the electric shock, the ladder being stable and not wobbling at all beforehand.
Counsel, can I ask you a question? Because I thought the facts were that the ladder had shifted and moved. And let me read you from page 451 of the record. And it was quite electrifying, pardon the pun. Line 5, do you remember the ladder wobbling and shifting before you were electrocuted? Answer, yes. I told you before, every ladder, you can feel that it's not steady, and it wobbles a little bit, so you can always feel, but this was yes. So isn't there testimony which would distinguish the cases we just discussed, that here we have a ladder that wobbled, and even before the electrocution, and even though counsel said he doesn't want to make an issue of the ladder, wasn't it bent, and wasn't it worn as to the feet below?
Okay, so I'll address each of those points in step. First, regarding the ladder itself, there's a photograph that shows that the ladder was not bent, was in good condition.
Counsel, the photographs show that the ladder was not in mint condition, that there were bent railings. It showed the erosion of the feet of the ladder. That's not accurate.
735. There's a picture of the ladder there that shows bent rungs. And those feet, the rubber, they don't look to be that stable either. They look a little bit worn.
Sorry, Your Honor, from my recollection from reviewing the photo,
But in any event, getting back to the Higgins case, in that case, again, the plaintiff received a shock or an arc fault. No mention of the ladder moving at all, at any time. So this person was thrown off the ladder, which is not what happened here.
I don't think it says that the person in Higgins was thrown off the ladder necessarily as a result of the shock. There was a shock in this case, there was a shock in Higgins, and in both circumstances, the plaintiff's movement was caused by the shock.
Where does it say here in Higgins and that the ladder moved as a result of plaintiff moving?
So
I read it, I don't know how many times this case. That's why I'm asking, and I didn't see that.
So I'm unsure exactly what your point is, Your Honor. I think
My point is that here we have the plaintiff testifying that when he received the shock, that he moved, the ladder shifted, and then he fell. Whereas in every other case, Cotea, Nazario, and this one, Higgins, there's no mention of any ladder moving at any time. And every single one of those plaintiffs were thrown off the ladder, as opposed to the ladder somehow shifting and causing them to fall.
So, Your Honor, here, plaintiff said that he ascended the ladder without issue initially, or twice actually, before the accident. There was no issue at all with his use of the ladder prior to being shocked.
That's not relevant here. that he was able to ascend and descend the ladder before is not relevant. The issue is at the time when he had the shock, did the ladder move? And he testified that it wobbled, which meant that while it was fortuitous beforehand, it doesn't necessarily mean that it was an inadequate safety device under these circumstances.
The ladder, plaintiff clearly testified that the ladder, he was not having any issues with the ladder until he was shocked.
Yeah, but I think Daniello makes clear that I don't think that that's relevant. I think we have to stay focused here.
Your Honor, I would say that this case is in line with the Court of Appeals decision in Kutaya from 2022. There was an electrocution here. There's a lack. I think the issue here, Your Honor, is about foreseeability and lack of foreseeability.
Thank you, counsel. We have your briefs. No, don't go yet, though. He has 2 more minutes. Sorry, I didn't mean to make it sound so final.
I'll be really brief. I think Higgins is important to give the court some further comfort in terms of distinguishing factors here. The defendant and Higgins did exactly what they should have done, which is faced with a prima facie violation of the statute. What did they do? They hired an electrical engineer. What did that electrical engineer say? He analyzed the voltage that ran through the plaintiff Higgins' body, and he said in his affidavit that it was analogous to a fire hose being turned on the worker and creating that kind of a force on his body. That's the type of evidence that a defendant like this would have to put in opposition in order to create an issue of fact, and that's exactly what this defendant didn't do. If there are no further questions.
I have a question. Why do you discount the evidence on page 735? And I pulled it out and I took the picture. There's a circle over, I think, 2 rungs where the plaintiff stated it was bent. And then at the bottom on 735, there's a picture of 2 circles where he said it was worn. So why isn't that not a factor in this case?
Judge, I guess there are 2 ways that we can win, and rhetorically, I think just respectfully, the cleaner, quote unquote, win for us is to remove any issue about whether that particular defect caused this particular wobble. Because in this case, if the external, expectable, foreseeable force of a small shock was enough to wobble an otherwise inherently good ladder and cause it to fall, that is a 240 violation. And that analysis doesn't involve or implicate any potential factual issue at all. But I do think we can win either way, if that makes sense. A Baker scaffold should have been provided. That's uncontested. That's admitted. We win 240 there. Or we could say the ladder was worn and defected and wobbled and fell. And either way, respectfully, 240 should have been granted.
Thank you, counsel.
Thank you.
Thank you both. Biswas v. Aramis Distributors. Please.
Good afternoon. May it please the court. Bernard Daskell for Appellants Fab USA and Fabi LLC. The motion court incorrectly denied appellant's motion to dismiss for lack of personal jurisdiction. I'd like to begin by just dispensing with the Fabi USA issue. It's merely a holding company. It manufactures nothing. Respondents did not put forward any basis for exercising jurisdiction over Fabi USA.
It has to be specific jurisdiction, right?
That's right. There's no.
So why shouldn't we allow some discovery on this? Have they made a sufficient showing to allow that?
No, Your Honor. In fact, respondents in their brief state, quote, on page 2, with jurisdictional discovery, facts may exist that would allow plaintiffs to make a sufficient start. They haven't made a sufficient start, and I think this court's decision in Norris and other cases indicates the failure to make a sufficient start means you don't get jurisdictional discovery. So that dispenses with Fabi USA, so let me turn to Fabi LLC. With respect to Fabi LLC, respondents say specific jurisdiction exists because Mr. Biswas encountered 2 products, both as a bystander to his mother's use, that purportedly contained Fabi LLC talc, and that those products were either purchased in New York or applied by his mother in his presence in New York while his family was on vacation there. But the record shows otherwise. The two products that respondents say are at issue are Estee Lauder Youth Dew Powder and CoverGirl Pressed Face Powder. I'm going to take those one at a time. I'm going to start with the Youth Dew product. Mrs. Biswas's mother, Anita Biswas, was specifically asked when she last obtained a container.
But isn't there something, I know you're about to say that she stopped buying it or she stopped getting it through the store, but there's something in the record that shows that potentially that she got gifts from people after the relevant period.
So let me
During
jump
the
right to that, Your Honor. I want to start with the point that there is unequivocal testimony. She's asked specifically, when did you last obtain this Youth Dew product? And she says, till about 2000. What happens is later on, there are other Estee Lauder products at issue that unrelated to Fabi LLC. She talks about another body powder. And what happened was after the questioning about the body powders ends, there's actually a break in the deposition. After the break, they come back. The questioner marks two photos as exhibits of a completely different product. That product was an Estee Lauder Lucidity Translucent Pressed Powder. And the questioners asked about these products and asks, and she testifies that she purchased these products in different shades.
Didn't she also testify? I mean, there may have been some confusion here, but didn't she also testify that she began using the Youth Dew powder in 1987 when the plaintiff in this case was just a few months old and last used it as late as 2016 or 2017? I mean, wasn't there testimony as to this? And don't we have to, not the other powder, but the Youth Dew powder?
So the reason why the use of the powder is irrelevant to the question for Fabi LLC, because Fabi LLC is a talc, it makes talc. It didn't start making the cosmetic talc until 2005. So she testifies that sometime up to 2000, she got 4 containers of the Youth Dew product. She could have used it until today, but the fact that she obtained those containers before Fabi LLC ever began making cosmetic talc means that it's impossible that those talc products contain Fabi LLC talcum.
Now, I know you must be familiar with this case that was handed up to us, which we read anyway, this Ludwig versus IMA Fabi, which deals with the same defendants. And can you discuss how we distinguish that, where they also allowed for some jurisdictional discovery to see what they may find out as to both of the companies, I believe?
Actually, in Ludwig, that decision is only asked to LLC. The court actually granted the motion as to USA. That's initially. Second of all, I would say that that motion, not only is there's been a motion to re-argue, there's an appeal up, and I could represent to the court, because I just heard from Upstate Counsel last night, and I saw the email. The plaintiffs have now offered to dismiss Fabi LLC because they determined that there is no connection between Fabi LLC and any product. And obviously, this was quite an issue for us because we want to make sure that that motion is re-argued or taken up on appeal. In addition, in that case, as I understand it, what the claim was, that there was CoverGirl, and I haven't had a chance to speak about that. I hope that the panel will give me a moment. I appreciate that. The claim was that the plaintiff had used the CoverGirl product in New York. I believe that that's the case. Also, here, Your Honor, again, there was, what happened, I think, in Ludwig is actually there was no discovery. The court just decided that they're going to find jurisdiction. But in this case, our point is there isn't even a sufficient start. If the Youth Dew product— I
understand that's your main point, counsel. You'll have time in rebuttal. Thank you.
All right, thank you, Your Honor.
Dan Woodard of Phillips and Palicelli for the respondent. I'd like to introduce Misty Farris, who's pro hoc vice, and request that she be permitted to participate in the appeal.
Granted. Thank you.
Thank you, Your Honor.
May it please the court. I'm Misty Farris on behalf of the Biswas. And I believe that, well,
Mr. Biswas says he concedes. He didn't use any product made by the appellants, right? It's only—
Mr. Biswas did not personally use the products. That's correct. His mother used the products, and despite what Emmy Fabi says, she purchased Youth Dew after 2005. Now, the reason we can say this is because when she said that she purchased Youth Dew shortly after 2000, she said that was because they were getting coupons to be able to continue to use the store. When she was asked later how often she was getting all these products, she said that how often she was getting these coupons, she said up until 2007 or 2008. And that's the more specific information about how long the coupons continued. As to the idea that when she said all of these products were purchased up until 2007, 2008, Emmy Fabi would say that that referred only to this compact that was available in different shades. In fact, just before that, she had been asked about all of the Estee Lauder products that she'd used, and she identified white linen, Youth Dew, something in a blue container, and a compact. And then when she was asked, when's the last time that you got all of these products, it makes sense that that refers to that list of products and not simply to the compact.
Oh, you unpacked that in your brief very well. Let's talk about CoverGirl, because your opponent's going to talk about that. How can there be any liability there from the Fabi defendants, anyway, when the mother can't even identify which CoverGirl product she used?
Well, I think that, first of all, Knoxell has identified Talc 141, which was supplied exclusively by Emmy Fabi as their primary source for their pressed powder product.
For the whole array of CoverGirl products that had talc in them?
Yes.
Okay.
Now, they will say primarily is not enough, but I would say if it's not, if we haven't made our prima facie case based on Youth Dew, and the court would decide that that is not enough, this primarily use of Emmy Fabi is not enough to make a prima facie case, which we would disagree with, that would be a perfect opportunity for jurisdictional discovery as to what Estee Lauder, the CoverGirl supply, and if that was exclusive in certain periods or what the relative use was as opposed to other products for the face powder.
What about the other company, the Fabi USA, which is allegedly just a holding company? How do we keep them in, or how even on jurisdictional discovery?
That is why we included the plant case. That case makes clear that there is discovery to be had as to Fabi USA, because the court, based on withholding of evidence, granted a new trial as to Fabi Diana, Fabi LLC, and Fabi USA. So we would say we've made a sufficient start toward finding that evidence may exist that Fabi USA was very involved in the talc business. I would also say that any Fabi defendants are trying to say that the evidence has to be viewed as they see it. And of course, that's not the standard on a motion to dismiss. We're entitled to every possible favorable inference, and we're entitled to have the facts in opposition to the motion taken as true. So I think that their attempt to say the facts must be taken as they find them is incorrect. If the court has no questions, we'll rest on our briefs.
Thank you, counsel.
Your Honors, if I may continue with the CoverGirl issue and also talk just a bit about the discovery issue. With respect to the CoverGirl product, what this court has said, and I believe Justice Kapnick and Justice Mendez, you were both on the Grasso decision decided earlier this year that said it is well settled that speculative assertions are not sufficient to defeat a motion to dismiss a lack of jurisdiction. And that's what we have with respect to the CoverGirl products. It's all, the court, in their briefs, the respondents are saying, we ask you to infer. They want you to speculate that it contained Fabi talc, that the talc was contaminated. There's nothing in the record that demonstrates any of this. In addition, and this is important to the CoverGirl product, which is Jurisdiction premised on the CoverGirl product would require that plaintiff had encountered that product in New York. And the record is absolutely devoid of any evidence of that. In fact, Mrs. Biswas testified because her son never mentioned anything about his mother using CoverGirl. And she said, well, her explanation was he probably didn't remember because I didn't use it that often. It wasn't part of my regular routine. I only used it for a brief period of time. She was asked specifically about where she used it. She testified about using it at her homes in Louisiana, about using it in Michigan, but she never testified about using it in New York. And plaintiff's counsel at the deposition asked Mrs. Biswas about 14 products. Mrs. Biswas, did you use Candid in New York in your son's presence? Yes.
I'm sorry, 1 second. Was there something in the record about the son being in medical school in New York and she would visit him and use the product visiting him in New York?
Her son ends up in medical school in New York, but no, not as the CoverGirl. All what happens, and this is the point I'm making now, Your Honor, is that she's actually asked about 14 different products by the plaintiff's counsel. Did you use this in his presence in New York? Did you use that in his presence in New York? It was so clear at the deposition to everybody that the CoverGirl product that she used only sporadically, not often, outside of her normal routine, was something that she never used in New York, and plaintiff's counsel therefore didn't even ask about it. There is absolutely no testimony in the record that she used that product in New York.
Thank you, counsel. Thank you both.
Thank you, Your Honor.
Levy Montefiore Medical Center.
Good afternoon, Your Honors. Nicholas Tam from Shabami, Sitcher, and Spratt, appearing on behalf of the appellant, Montefiore Medical Center. The trial court's decision should be reversed for want of questions of fact on both liability and causation. I'll start with causation because in reviewing the expert affirmations, there's very little daylight between their opinions on whether or not the patient was hemodynamically stable after the issue with the rotoblader's foot pedal was found. If you go to page 97 of the record, defendant's expert, Dr. Slater, indicates that at 3:59, the patient was hemodynamically stable and could have been surgically revascularized. This is echoed in the plaintiff's expert affirmation on page 3509, where their expert indicates, quote, at this point, there appears to be sufficient LAD flow to avoid life-threatening hemodynamic compromise. Thus, another point at which the procedure could have been stopped. At that point,
But I mean, I understand that, and I understand that Dr. Shi is still in this case, and that's not an issue for the appeal, and that Montefiore is still in on vicarious for Dr. Shi. So these are just the direct claims.
Direct claims, correct.
And so there was a lot of discussion, and included in both experts' reports, a discussion about the fact that this machine that was used was not working at the time, or at least the foot pedal portion of the machine was not working.
Yes.
And both sides said that that could be a departure, a potential departure from the standard of care. So how do you get out of that? How do you get out of that? I mean, there's no dispute that if the machine had been working, he would have used that machine and he wouldn't have had to think, what else could I do? Maybe his choices of what to do were wrong, but how does that not constitute a proximate cause of what happened here?
It's not a proximate cause because
Why
the
is
plaintiff's
that?
expert never competently establishes how testing the foot pedal alone ensures that everything works together. And what everybody, all the experts indicated, and the doctor himself indicated, was that it's a, strike that. What Dr. Shi indicated was that it's a pre-procedure testing process only because they use a single-use device. The burr and the advancer come out of the sterile packaging, and that can only be tested just before you put it into the patient and perform the atherectomy procedure. What plaintiff doesn't reconcile is that you can't just test the foot pedal alone, because that doesn't ensure that the entire chain, the entire device works as one cohesive unit to ensure that the burr itself spins at the optimal RPM. And that's what you really need in order to get the machine to be working. On to my next point regarding causation. Both experts also agree that this patient could have been rescheduled at a further time down the line.
Because the patient was hemodynamically stable at that particular time, is that correct?
Heart rate was normal, BP was normal. The patient could have been, everything could have been stopped at that point. Dr. Shi did not need to do 6 successive balloon angioplasties. That was not a reasonable, foreseeable event. Plaintiff's expert doesn't say it was reasonably foreseeable, but it is argued on appeal. And on page 3503 of the record, plaintiff's expert indicates good and accepted interventional cardiology practice would have been to allow the patient to rest, cancel the procedure, and reschedule for another time. And it's repeated again on 3514 and 3516. Thank you.
Thank you, counsel. You have time to rebuttal.
Thank you, Your Honors. May it please the court. Beth Gehrig for the plaintiff respondent. I think before we get to pulling apart the actual testimony about how the machine works, we have to look at what the actual claim was, which was made against Montefiore. And the claim was that they did not properly maintain this machine. And they didn't make their prima facie burden of showing that this machine was properly maintained. It wasn't until the actual reply papers that they first gave us maintenance records.
But then we have to deal with causation after that, right? Because then she could have gone home when the machine wasn't working.
I disagree respectfully, Your Honor, and we have Dr. Shi's testimony there to help us. According to his own testimony, when we're looking at pages 1101 to 1102 of the record, before he actually does the alternative procedure, he testified that she had chest discomfort, EKG changes, flow of blood through the LAD was decreasing, she was anxious, she was declining. He said that this was no longer at this point because there was such a prolonged delay in waiting for the other foot pedal to come from their sister hospital.
Counsel, when was that? Because I'm confused. At what time? At 3:59 it stopped working. Why couldn't he just, at that point in time, just discontinue the procedure, stabilize the patient, go to the ICU, and consult with another doctor? So when is it that you're saying that the patient was unstable?
According to him, it was documented as of 2:55. He said that she was, the only thing that was actually in the records was that she had anxiety, but that he was looking at the actual EKG. If you give me 1 second, I have the pages right here. If we look at, in addition to at 2:55, then he starts talking about at some point prior to 4:43, he made the determination that they couldn't wait any longer for the machine to come back. And that's at page 1178.
At what time?
This was afterwards, he said, at some point prior to 4:43.
Okay, so
He also testified that at 2:55, that there was a indication that she was anxious. They had to give her more sedation. And as plaintiff's expert explained when you have somebody with such significant health issues, the fact that she's anxious and she's having heart palpitations and everything else, they had basically decreased her ability for the proper cure. What's happening here is because of the delay, because they didn't have the machine available, and Dr. Shi testified that it was his expectation that the machine would have been there and available for him, that if he knew the machine had not been available, he never would have transversed the wire across the LAD. And once he transversed the wire, it was his belief that he then had no option but to wait for the other atherectomy pedal to come from the other hospital. At some point while they're waiting for this to happen, she is now declining. And instead of it now being an elective procedure to go from the atherectomy to the angioplasty, they had to do this, and he said we had to do this to stabilize her. The fact that he testified that we had to do this to stabilize her, therefore
Counsel,
she was not
I have to stop you. Isn't that the opposite of what your expert said? And I can read it to you. Good and accepted interventional, this is on paragraph 29. Good and accepted interventional cardiology practice would have been to allow the patient to rest, cancel the procedure, and reschedule for another time. That was at the moment when it stopped working, or the foot pedal. That's what your expert said.
Absolutely, but we're also able to argue in the alternative, and that's what we're arguing against Dr. Shi. Here, there are independent acts of negligence, and there could be more than one proximate cause of the injury. And here, we also have, as a proximate cause, the hospital's failure to maintain and provide a properly working machine. If you look at the record at pages 1184 to 1185, Dr. Shi is very clear that they had to open up her vessel at that point to stabilize her. That's why they had to do the angioplasty, at that point, because she was no longer stable while they were waiting for this machine. And if he had known that there was not a machine there to use, not a properly working machine, then he never would have transversed the wire, and they never would have been in this position in the first place. We ask that even if you find that they did make their prima facie in addressing the failure to maintain the machine, which we don't believe they made, and then you get to the issue of proximate cause, that you find that the lower court was correct in finding on this record there were issues of fact. And
Thank you, counsel.
Thank you.
Your Honors, I think it's interesting that they go back on their own plaintiff's expert's words and start citing Dr. Shi's testimony when their expert incorporated all of Dr. Shi's testimony and said, despite all of that, at 5:18, when the 6th balloon angioplasty was inserted but not inflated, the patient still could have been surgically revascularized, and I think the court pointed that out. And one part that I did not touch upon was that the entire procedure, the captain of the ship in this case was Dr. Shi, who exercised his independent medical judgment. These direct claims against the hospital should fail.
Counsel, we're left with vicarious liability then.
Correct. That's it. If there's no further questions, I'll rest my brief. Thank you.
Thank you, counsel. Thank you both.
Thank you.